To an exercise of administrative powers.
Yes, sir.
I'm trying to make your life easy, but if you don't want it to be made easy, that's fine by me. Please don't interrupt. I've requested you, please keep noting the queries. Naturally, you have a chain of thought, you have submissions. We don't want you to get, I can appreciate your position. So many judges, so many questions, which one do you answer? And then your argument is lost sight of and you go somewhere else. So please persevere with your thing, keep noting the questions and you can address them. So I'm trying to make your life easy, unless you don't want it to be made easy. So proceed with your case. Note the question, respond to it later.
To be very honest, I welcome this interruption.
Can I ask a question? Can I ask?
All right.
Please. What about the office of the Chief Justice after passing of this act? Don't you think that the office of the Chief Justice would become redundant? Because you would be left with no powers then.
We noted this down, and in fact, I would say that the Chief Justice powers will be whittled down, as if this law goes through, the powers will be whittled down, but we'll explain it in something. And this has been held in many places, that the Chief Justice has the power to form the benches, is the rooster, and I can go back years and years when a chain of judgments have come in, and the latest one is, of course, 2000. I will continue. Let me
note kar le hain, baad mein kar rahe hain.
Let me continue.
Mr. Khwaja, I will add.
Then is a question.
Mr. Khwaja.
Yes, sir.
Right side.
Right side. Okay.
I will add to it. Whether the power of the Supreme Court has been curtailed or the power of the Chief Justice. I think that's the moot question.
The answer to that is that it's been noted, sir. It's noted, and I will only say this thing, that Supreme Court, what is Supreme Court? Supreme Court is Chief Justice and so many other judges.
Wajah will be sitting here till 12 o'clock.
I know that, sir. Let's
अपना argument करें. अभी जो हम section 3 पे पहुंचे.
Let me, on section 3, I will only say this thing, that this certainly is the Parliament has taken away the power not only from the Supreme Court and the judges, but also it has condemned me unheard and violated the provisions of Article 10A, which provides for a fair trial. Because I will file a petition. I've not even heard, and 3 judges or 2 judges, they will decide on an administrative side, and I'll be out. So the question of 184(3) will become totally redundant. This is my point. Therefore, to that extent, section 3 is present. Now, next is 4. Interpretation of the Constitution. In the matters where interpretation of the constitutional provision is involved, committee shall constitute a bench comprising not less than 5 judges of the Supreme Court.
Do you object? First say, I object to this provision, or you endorse it?
I will say this, sir, that in the matters of interpretation of the Constitution, when you are, all the judges are competent to interpret the Constitution. By limiting it to 5 or limiting it to 3 or why not 7? Why not 6?
Please.
I object to this thing, that this is a limitation.
No, it's not a limitation. It says not less than. It could be a full court like the present court. So are you just safe? Is this ultra vires the Constitution, section 4? Say something, we should note it.
On this, I will only say this thing, that putting a clause that the bench should be not less than 5, that possibly is expressing, shall I say, not confidence in less than 5 judges. Because this is very strange, because all judges are equal. Your Lordship is the first amongst the equal, but every other judge of the Supreme Court has the same powers and the same acumen. So by saying this thing, not less than 5. Then there's a question of appeal, and which is a very relevant point.
Ajay Sahab, as I understand your earlier proposition, you are satisfied that the Chief Justice in the previous model, being the master of the roster, had untrammeled power to constitute a bench of 3 members, and you were satisfied with that.
I have noted this thing.
Yes.
Your Lordship did not, sir. I will not be able to explain. It's my shortcoming.
Explain later.
On the question of benches, I have stated with this thing that this power should be exercised by the full court, not by the Parliament. How the benches are to be.
आगे बढ़ते हैं.
I will dwell on that.
In a nutshell, you are suggesting that the powers as master of the roster in the Chief Justice were also unconstitutional.
No, sir.
This is your suggestion.
No, sir. I'm saying this thing that under the 1980 rules, that power had been given. If all of you sitting together feel that under 191 that this should be changed, then it is your function. It is not the function of the Parliament.
Okay, now let's proceed. We'll ask.
I'll do on that. That is the point which needs consideration. 5 is appeal. Yes, Mari sir.
On section 4.
On 4.
If memory serves me right, section 4, what is the equivalent of section 4, is part of the Indian Constitution as an article of that Constitution. It was a part of the 1956 Constitution as an article of that Constitution. Now, question is that when the framers of the present Constitution had before them this model where this very power was conferred on the Supreme Court in the way that what in India they are called constitution benches, the question is this: that model, that aspect was not accepted by the framers of the present Constitution, because they had a model both from India and from Pakistan itself. So the question is this: if that was not accepted, does this not require constitutional amendments? Can Parliament do something which the framers of the Constitution deliberately seem to have left out, despite the earlier models? Can Parliament then, in exercise of sub-constitutional jurisdiction, namely legislative competence, do something that was earlier part of the Constitution? This is the question. Please note.
Yeah, it's noted, sir, and I may add on to this.
साहब मैं एक सवाल पूछ लूं आपसे, अगर उसी में डाल दें आप लिस्ट में अपनी.
जी
मैं इधर हूँ जी. मैं बस सिर्फ सिंपल सा आपकी जो समझ आई है मुझे आपकी कि ये सारा कानून अगर यही सारा को फुल कोर्ट बैठ के बना ले तो सब ठीक है.
नहीं सर,
सुन लीजिए, सवाल तो सुन लें.
जी जी.
कि 17 जज बैठ के ये सब कुछ बना ले तो ठीक है, पार्लियामेंट ये सारी चीज बना दे तो गलत है. ये आपकी बहस है ना सारी?
नहीं सर, ऐसे नहीं है.
आपने यही कहा, आपने कहा ये सारी चीजें करो, लेकिन
नहीं सर ऐसे नहीं.
सुप्रीम कोर्ट
नहीं सर ऐसे नहीं है.
चलिए बस नोट कर लीजिए.
मैं नोट कर लिए. जब सुप्रीम कोर्ट एक
आप जवाब ना दीजिए ना, बाद में
जवाब दे.
ठीक है, अदरवाइज तो आपकी मुश्किल काम हो जाएगा.
आई एम क्वाइट वेरी
आगे बढ़ते हैं.
I have worked with all of you, sir.
आगे बढ़िए.
I have no problems.
हजूर आगे बढ़िए, आगे बढ़िए.
मुझे कोई प्रॉब्लम नहीं है. I understand what Shah Sahab is suggesting and saying, and he has mentioned this in many other cases. Yes, ma'am.
If I may ask a question as a supplemental to the question that my learned brother, my learned colleague has asked. Independence of the judiciary is a recognized fundamental right.
Yes, ma'am.
So the question, surely, this is the question to you. Surely, the question of what the court can itself do to regulate its own practice and procedure is now encased in independence of the judiciary, and can Parliament intrude upon, with all due respect to Parliament, they have their legislative competence, the Constitution is supreme, that is what is paramount, that is what is there. Can Parliament, in professed exercise of a legislative competence under Article 191, trample upon, I'm using this word a bit deliberately, I don't intend to show any disrespect to Parliament, but can it encroach upon or intrude upon something that would affect independence of the judiciary, something that relates to practice and procedure, which the court may or may not do, but can do for itself? Can Parliament do that? In other words, when Article 191, this is part of that question, starts with subject to the Constitution, the law part of it is also being subject to the Constitution, and the Constitution says independence of judiciary is a fundamental right. Can Parliament directly or indirectly take away a fundamental right?
Not through ordinary legislation.
आप note कर लें.
Not through ordinary legislation.
If I will really request my colleagues